Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to go over Sabrina's case, an update. We talked about her motion to quash, and now we're going to talk about what she filed as well, which was in opposition to motion to dismiss. Let's look at the docket. In the docket you can see here, let's go to the top. Okay, case number 423-CV-01332 in the Pacer court docket. You can see that her case was filed 10/23, and if you go down, let's go to where they filed their motion to dismiss. That's Midland Mortgage. The other bank, which was New American Funding, they were in default, so the only motion to dismiss was filed by Midland Mortgage on 12/15/2023. So she has to file she had to file a responsive motion, and she did it in 7 days instead of 14. And here it is right here, response to opposition to motion. So let's look at that. Okay, the first page says plaintiff's memorandum. Wait a minute, that's not the first page. Let's go to the first page. Okay. Plaintiff's opposition to defendant's motion to dismiss. And basically it states, comes now plaintiff Sabrina Kohler, pro se, does hereby files the following to oppose the defendant's motion to dismiss. Plaintiff does not waive any jurisdictional arguments. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim for relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content and allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Defendant states on the second paragraph of the first page of their motion to dismiss the following. Plaintiff fails to state a claim against MidFirst Bank under the Fair Debt Collection Practices Act because she has not alleged facts establishing that MidFirst Bank is a debt collector as necessary under the Act. Midland Mortgage is a mortgage servicer, and on every statement that was mailed to the plaintiff, it states clearly that they are a debt collector. Additionally, the plaintiff's loan was in default when it was transferred to Midland Mortgage. This opposition to defendant's motion to dismiss with plaintiff's memorandum of law in support will provide more than enough proof that plaintiff's claim will survive the Rule 12b-6 argument made by the defendant. Okay, so next page, plaintiff's memorandum of law in support of opposition to defendant's motion to dismiss. Table of contents. All memorandum of law should have a table of contents and a table of authorities. So her table of contents says background, defendant's motion to dismiss fails, defendant in default, successor mortgage servicer is liable, Missouri Revised Statutes 443-930, quiet title claim, fraud, Midland Mortgage is a debt collector, and conclusion. Table of authorities. This is the cases that she cited in her memorandum of law and the statutes. Okay, so the first page says, comes now Sabrina Kohler, pro se, does hereby file this memorandum of law to support the opposition to defendant's motion to dismiss as follows. And we have a background. We always have to do the background. The plaintiff filed a complaint in the federal court of the Eastern District of Missouri on October 23, 2023, under this docket number. The defendant, New American Funding, doing business as Broker Solutions, received a copy of the complaint by personal process server on November 3, 2023. The defendant, Midland Mortgage, received a copy of the complaint by personal process server on November 2nd, 2023. On November 21st, 2023, defendant Midland Mortgage filed an entry of appearance for Benjamin Levin and Bradley Anderson, attorneys. On October 21st, 2023, defendant Midland Mortgage filed a motion for extension of time to file a reply response. This was granted on November 27th, 2023. Defendant New American Funding, doing business as Broker Solutions, failed to respond to the complaint. Plaintiff filed a notice of default on defendant New American Funding, doing business as Broker Solutions, on November 27, 2023. The clerk's notice of default was filed against defendant New American Funding, doing business as Broker Solutions, on November 28, 2023. Defendant Midland Mortgage filed a motion to dismiss on December 15, 2023. Defendant's motion to dismiss fails. Defendant Midland Mortgage filed a motion to dismiss under Rule 12b-6 for failing to state a claim that relief can be granted. Fails for several reasons. Consideration of the plaintiff's complaint as a whole demonstrates that it meets the requirements established under the federal rules. A complaint must contain sufficient factual matter to state a claim for relief that is plausible on its face. Ashcroft versus Iqbal, however you say it, and Bell Atlantic versus Twombly are the two that they always cite in all these motions to dismiss. So we're going to cite them as well. The standard is met where the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Here the complaint presents a detailed recitation of plaintiff's assertions that more than satisfies the pleading requirements. A review of the entire complaint demonstrates that the complaint in no way relies on mere legal conclusions, but contains detailed factual account of defendants' illegal practices, which establish their liability for the violations made against the plaintiff. Defendant Midland wants the claims against them dismissed. However, they have the lien that is encumbering the plaintiff's property. To dismiss the claim would be the legal equivalent of throwing the baby out with the bathwater. Defendant in default. Defendant New American Funding, doing business as Broker Solutions, hereinafter NAF, is in default for not answering the complaint. As a result, the allegations against NAF by the plaintiff, Sabrina Kohler, must be taken as true. The facts that must be taken as true are as follows. Sabrina Kohler never signed a promissory note or mortgage on October 20th, 2020. Defendant NAF is guilty of committing identity theft and fraud against the plaintiff. Defendant NAF is guilty of not crediting payments and charging unauthorized fees. Defendant Midland Mortgage, although not in default, is the successor servicer, and by being so, is guilty of ignoring the plaintiff's letters, telephone calls, and emails regarding the origination of this fraudulent loan. Defendant NAF sold the fraudulent loan to Midland Mortgage. Defendant Midland Mortgage has no right to collect payments or declare the plaintiff is in default over a fraudulent loan. Defendant Midland Mortgage may claim it is innocent of any wrongdoing, but the fact remains that it must be held accountable for the wrongdoings by defendant NAF. Successor mortgage servicer is liable. A successor mortgage servicer is liable for a previous servicer's misconduct. And you can see Conway versus City Mortgage for that one. In Conway, the Missouri Supreme Court held that a subsequent owner of a service or servicer of a loan could be held liable under the Missouri Merchandising Practices Act, hereinafter MMPA, for unlawful conduct, even though it was not a party to the original transaction. Often referred to as Missouri's Consumer Protection Statute, the MMPA is designed to protect consumers from untruthful, misleading, and unfair business practices. This also falls under the FDCPA. This instant case, like the Conway versus City Mortgage case, raises the issue of when the actions of a loan servicer who is not a party to the initial transaction are in connection with the initial sale of the loan. In Conway, it was determined that a plaintiff may state a claim under the MMPA against a loan servicer who is not a party to the original or the initial transaction for the alleged wrongful foreclosure on a deed of trust. And then there's other case law here as well. The Federal Rules of Civil Procedure under Rule 9b mandates a heightened pleading standard for fraud-based claims. Now it's saying here that to satisfy the Federal Rules of Civil Procedure 9b's requirements, the complaint must allege such matters as the time, place, and contents of false representations, as well as the identity of the person making the misrepresentations and what was obtained or given up thereby. Plaintiff will prove she has satisfied this requirement in the section called Fraud on page 9 of this Memorandum of Law. Now it talks about the Missouri Revised Statutes 443-930. Prohibited acts constitutes mortgage fraud. And you guys can read this if you want to. We won't get into it right now, but you guys can see what constitutes mortgage fraud, and that needs to be in here. Quiet title claim. Under Missouri law, anyone claiming an interest in real property may institute an action against any person or persons having or claiming to have any title, estate, or interest in such property to ascertain and determine the estate, title, and interest of said parties. Respectfully, Missouri Revised Statute 527-150. As discussed above, plaintiff has alleged sufficient facts to demonstrate a plausible claim to the property and can therefore bring claim to quiet title to the property in question. And it says Missouri Revised Statutes, a plaintiff in an action to quiet title has the burden to prove title superior to the other party, not superior to the whole world, and must prevail on the strength of its own title and not on any weaknesses of the title of the other property. Midland claims that the quiet title claim against it should be dismissed because plaintiff has not alleged specific facts pertaining to MidFirst Bank as opposed to its co-defendant, New American Funding. Midland Mortgage bought the fraudulent note and deed of trust and servicing rights from NAF. Further, they have all the servicing records regarding the fraudulent origination, customer service inquiries, telephone calls, letters, and misapplication of payments. To dismiss Midland Mortgage from this case would be premature, especially before discovery has been completed, as this would be prejudicial to the plaintiff's claims. Plaintiff has been threatened by foreclosure by both NAF and Midland Mortgage. Midland does not deny any of the fraud claims against the defendant, NAF. The court may find that there are no general issues of material fact regarding the fraud committed by NAF and that the plaintiff is entitled to judgment as a matter of law. The lien created by NAF should be declared null and void, and Midland Mortgage has the responsibility to expunge this lien. Now we're going to talk about fraud. In the state of Missouri, a fraud claim for a fraudulent misrepresentation, they must prove 9 essential elements. And we're going to go through each one here. A representation, NAF fraudulently misrepresented that the plaintiff was suffering a financial hardship during the COVID-19 pandemic. 2, its falsity. NAF falsely drew up loan applications, note, and mortgage with false information on it. Its materiality. NAF forged signatures of the plaintiff to acquire a new loan without her knowledge. 4, the speaker's knowledge of its falsity or ignorance of its truth. NAF's brokers lied several times regarding the loan applications and loan documents that were located on their website and email communications that the plaintiff thought was true. The speaker's intent that it should be acted on by the person in this matter reasonably contemplated. Plaintiff hesitantly acted on by making mortgage payments on a brand new mortgage loan that she never signed or agreed to. The hearer's ignorance of the falsity of the representation. Plaintiff had no idea that NAF Broker Solutions had paid off her own old loan and started a new one. The hearer's reliance on representation being true. Plaintiff thought that if she did not pay her new mortgage loan, that her loan would be in default and her home foreclosed on. Number 8, the hearer's right to rely thereon. Plaintiff relied on NAF because this was the only mortgage lender she had dealt with. She paid on her first loan religiously, never missing a single payment, making extra payments to principal, and then suddenly discovering a new loan number was shocking. Number 9, the hearer's consequent and proximity cause injury. Plaintiff injuries are that she had paid down her first loan in a substantial way, that the amount of interest and principal was much less than having to start back to square one with a new loan. Further, plaintiff had never agreed to getting another FHA loan because of the added cost of the insurance premiums. Plaintiff contacted NAF demanding an explanation of why she was given a new loan when there was nothing wrong with her old loan. NAF replied by sending her this email, which says, by Brittany Aguilares, I am reaching out to you in regard to your recently closed loan with us, New American Funding. During a recent post-closing audit, a document, the note, was damaged during delivery from your closing to us. If you can please confirm a date, time, and place to best contact number, we can send out a notary free of charge to have this re-signed as quickly as possible. There are no changes to your loan terms. This is merely to replace the damaged document. The plaintiff never signed this damaged note or a new one. A copy of this email is attached hereto as Exhibit A. Midland Mortgage is a debt collector. Defendant Midland Mortgage is trying to say in their motion to dismiss they are not a debt collector defined by the FDCPA. They claim that the loan was not in default when it transferred to them. Plaintiff will prove that the loan was in fact in default when Midland Mortgage received it. The loan was sold to Links Whole Loan Acquisition LLC on April 5, 2022, according to an email from NAF. A copy of this email is attached hereto as Exhibit B. Links is a debt collection agency business located in Denver, Colorado. The plaintiff's loan was already in default status when it was transferred to Links. A monthly mortgage statement dated May 17, 2022, states that plaintiff was 289 days past due. A copy of the statement is attached hereto as Exhibit C. Plaintiff was charged default servicing fees. Okay, has some case law there as well. Okay, Midland Mortgage sent statements to the plaintiff that state the same information. A copy of the statement from Midland Mortgage shows they are a debt collector is attached as Exhibit D. Okay, so conclusion. Wherefore, based on the foregoing, the plaintiff prays that the defendant's motion to dismiss will be denied. Plaintiff's complaint does sufficiently allege a claim for relief to be granted from the fraud that was perpetrated against her by NAF. Midland Mortgage, the successor servicer, is liable to refund the plaintiff for the monies that are owed back to her regarding the fraudulent loan originated by NAF. Midland Mortgage is a debt collector under the FDCPA. The claims against Midland Mortgage should not be dismissed because it now owns all the servicing records that the plaintiff can show through discovery to prove that she's entitled to relief. Alternately, the court may rule that plaintiff may amend the complaint to cure any deficiencies against Midland Mortgage. And that's the end of that. You got a certificate of service, because you always have to serve the other side. Exhibit A. This is that email that says that the note was never signed. Unsigned note is pretty important. Here's the Links Whole Loan Acquisition right there. It's dated April 5th, 2022. Exhibit C shows the loans in default. It shows how much right here. It also says the date May 17th, so you know it was in default at that point. And then Exhibit D, Midland Mortgage, they say they're a debt collector. As you can see right there in small print, they are a debt collector. So that's the end of her motion. She's got a proposed order at the end, which you always have to include. I hope this has been informative to you guys. Hope everyone has a good Christmas. And if you have any questions, you can always email me at foreclosurehelp777@gmail.com. Y'all have a good one.